Ladies and gentlemen, as our final round of Vietnam CI Trip Remove 2022 is about to begin, please be prepared and make sure you have a stable network connection to avoid interruption. Thank you for your kind cooperating and attention. Good afternoon, ladies and gentlemen. Welcome to the final round of Vietnam CI Trip Remove 2022. I'm Châu Giang, and it's my great honor to be your MC for this final round today. On behalf of the organizing committee of Vietnam CIG Pre-Moot 2022, we are delighted to welcome all of you, the arbitrators, contestants, distinguished guests, and viewers to come to the annually held competition, Vietnam CIG Pre-Moot 2022. Ladies and gentlemen, Vietnam CIG Pre-Moot is a competition co-organized annually by 4 institutions, namely Foreign Trade University, Vietnam International Arbitration Center, Vietnam Business Law Club, and Vietnam Society of International Law. It is also important to mention the valuable support of Foreign Trade University Youth Union, Law Consulting Club LCC FTU, and CISG Vietnam. Over the last 3 seasons of Vietnam CIG Pre-Moot, our competition has attracted attention from hundreds of students from various top law universities across Vietnam, while giving them a chance to learn, to apply CIG provisions, to understand, and to improve their ability to resolve disputes in English, thereby contributing to creating new generations of judges, arbitrators, lawyers, and experts in the field of international trade law. This year, Vietnam CIG Pre-Moot 2022 has returned with a view to helping law students reinforce their legal knowledge and skills. After 3 challenging rounds with multiple teams coming from universities in Vietnam, 2 teams have made it to the final round today. They are Team MMA and Team 1900. Today, let's find out who will be the new champion of Vietnam CIG Pre-Moot 2022. To begin with, we are pleased to welcome our beloved guests, sponsors, arbitration tribunal, and viewers, especially students from various law universities all over Vietnam. We would like to thank you sincerely for partaking in our event today. We would like to invite Associate Professor Dr. Phạm Thu Hương, Vice President of Foreign Trade University, to deliver the opening remarks. Please welcome.
Distinguished guests, arbitrators, teachers, students in audience. It is my great honor to be on behalf of Foreign Trade University to warmly welcome all of you to the closing ceremony of CISG Pre-Moot 2022 today. Vietnam CISG Pre-Moot is the first moot contest on CISG in Vietnam, based on the well-known moot competition around the world, such as the Vismoot in Vienna, Vismoot in Hong Kong. And Foreign Trade University is very proud to be the organizing committee of such contests for 3 consecutive years, with the design not only foster the study of international commercial arbitration and law, but also provide the practical playground for students to train to resolve international business dispute. And I believe that the competition will be the very good preparation step for Vietnam competition team to participate in the international moot contest. And this year, the competition has successfully drawn the interest in participation of 16 excellent teams from 8 universities across the country. And after 2 intensive days of the elimination, quarterfinals, semifinals, and today we reach the final round with 2 excellent, outstanding final teams. And to the challenging competition round, I believe that all competitors, all teams have to only impress the judges with their great confidence, intelligence, and creativity. Congratulations to all of you. And on behalf of Foreign Trade University, I would like to express our sincere thanks to all local and international experts and arbitrators who spend a very valuable time for this competition. And the participation of all of you plays a very key role in helping us to choose the best team. And we would like to thank to our esteemed partner, the Vietnam International Arbitration Center, VIAC, Vietnam Society of International Law, VSIL, and Vietnam Business Law Club, VBLC, for your great efforts in co-organizing this meaningful activity. And thanks to all sponsors for your continued support in our company throughout the competition. Ladies and gentlemen, I strongly believe that Vietnam's CISG Premier 2022 has successfully transformed the COVID-19 challenge into the opportunity of novel and unique experience of virtual moot court arbitration for all contestants and arbitrators. And I'd like to set the last word for our students. This competition is closing, but the door of opportunity is always open. And you have or maybe learn a lot along the way. And I believe that you will continue demonstrate your talents, courage, and learning spirit to achieve the greatest success in future. And may I wish all of you good health, happiness, safety, and once again, good luck to our outstanding team of the final round today. You are already winners of today. Thank you very much.
Thank you, Associate Professor Dr. Phạm Thu Hương, for your motivational opening message. Ladies and gentlemen, the accomplishment of the competition cannot be achieved without the generosity, hospitality of our co-organizers, supporting units, and sponsors. To our sponsors, I would like to introduce silver sponsor includes Zooms and Associates and ADR Vietnam Chambers, LLC. Bronze sponsor includes Hợp Đặng Chamber and Appellate Legal. On behalf of the organizing committee of Vietnam CIG Premier 2022, we would like to express our profound gratitude to all of our sponsors. Your support is an integral part of the competition's success, and we clearly look forward to cooperating with you in the future. To begin with, I would like to invite Mr. Nguyễn Mạnh Dũng to deliver the speech. Please welcome.
Kính thưa quý vị đồng nghiệp và toàn thể các em sinh viên, hôm nay tôi rất vui được gặp gỡ, giao lưu với các quý vị đồng nghiệp và các em sinh viên tham gia cuộc thi Việt Nam CSG Pre-Moot 2022. Việt Nam đã là thành viên của CSG và các quốc gia thành viên của CSG hiện chiếm phần lớn kim ngạch xuất nhập khẩu Việt Nam. Hàng năm, tổng kim ngạch hàng hóa xuất nhập khẩu Việt Nam đạt hơn 600 tỷ đô la, gần gấp đôi GDP. Tại Trung tâm Trọng tài Quốc tế Việt Nam VAC, các vụ tranh chấp liên quan hợp đồng mua bán hàng hóa, trong đó có mua bán hàng hóa quốc tế có thể áp dụng CSG, chiếm tỷ trọng lớn nhất, lên tới 44,4% tổng số vụ việc được xử lý trong năm 2021. Tranh chấp trong lĩnh vực thương mại quốc tế cũng là loại hình tranh chấp phổ biến nhất tại Trung tâm Trọng tài Quốc tế Singapore SIC, với 64% tổng số vụ việc được xử lý năm 2020, là năm mà SIC đạt kỷ lục cao nhất về tổng số vụ tranh chấp được xử lý trong số các tổ chức trọng tài quốc tế. Cho tới nay, CSG là một trong các điều ước quốc tế được phổ biến và áp dụng rộng rãi nhất với 96 quốc gia thành viên trên thế giới. Mặc dù vậy, các nguyên tắc của CSG vẫn còn khá mới đối với hệ thống pháp luật Việt Nam, cũng như đối với giới luật sư thương mại. Thông qua cuộc thi này, tôi hy vọng rằng các bạn sinh viên có cơ hội được trau dồi kiến thức trong lĩnh vực giải quyết tranh chấp thương mại quốc tế nói chung và giải quyết tranh chấp bằng phương thức trọng tài nói riêng. Do vậy, bất kể thứ tự xếp hạng của cuộc thi như thế nào, tôi tin chắc rằng mỗi bạn sinh viên tham gia đều có cơ hội học hỏi được những kiến thức cũng như những kỹ năng hữu ích trong việc giải quyết các tranh chấp thương mại quốc tế. Đó không chỉ là kỹ năng tranh tụng tại các phiên họp, mà còn là việc xây dựng chiến lược xử lý vụ việc, áp dụng những chiến thuật khác nhau trong từng giai đoạn tố tụng, hay những kỹ năng cụ thể trong việc soạn thảo và làm việc nhóm. ADR Vietnam Chamber là platform đầu tiên của các trọng tài viên, hòa giải viên hành nghề chuyên nghiệp ở Việt Nam. Rất hân hạnh được đồng hành cùng các bạn sinh viên và chúc ban tổ chức cuộc thi và các quý vị đồng nghiệp mạnh khỏe và thành công. Chúc các bạn sinh viên gặp nhiều may mắn.
To our organizing committee, I respectfully introduce Foreign Trade University FTU, Vietnam International Arbitration Center, VIAC, Vietnam Society of International Law, VSIL, and Vietnam Business Law Club, VBLC. Supporting committee includes CIG Vietnam as Professional Support Unit and Law Consulting Club, LCC FTU, and Organizational Support Unit. We appreciate your enrollment in supporting the committee to organize Vietnam CIG Pre-Moot 2022. Thank you all again. Ladies and gentlemen, I would like to introduce the arbitration tribunal, who have contributed greatly to the contribution overall success and will be in charge of deciding the winner today. Now I'd like to introduce the composition of the tribunal for the final match. Mr. Harold Sipple, Academic Director of Bali International Arbitration and Mediation Center, BIAMC, the tribunal's president. Harold combines the experience of over 80 arbitrations as arbitrator, counsel, and administrative secretary with approximately 300 arbitrations and heads of legal service at Asian International Arbitration Center, VIC. Harold has been working with moot court teams over a decade. The second of the chamber is Mr. Nguyễn Trung Nam, founding partner of EP Legal, ranked as the leading lawyer in chambers and partner, Asia Pacific, the Legal 500, Asian Law Profiles, and other highly regarded international legal directories. And finally, the final panelist of the chat is Mr. Lê Bá Thành Trung, Managing Partner, CLVN, a project and construction law specialist firm. Ms. Chung is qualified to practice in Vietnam, New York, and before the Supreme Court of the United States. We sincerely thankful for your presence in this season. For the time being, I'd like to invite Mr. Harold Sipple, the tribunal's president, to make a speech before the commencement of the final round. Please welcome.
Thank you very much and good afternoon. It's my great pleasure and honor also, above all, to be acting as an arbitrator in today's match, arguably the most important match, as we will decide the winner. But as much as I say the winner, I believe, and I sincerely believe that I'm not just saying this, to sound nice. I believe everyone who participated in this competition is already a winner. Moot court competitions, above all, are not about coming out on top and being ranked #1. Of course, this is what we all try to achieve. But moot court competitions, the way I see them, are really a journey, a personal journey, a journey of self-improvement, a journey of reaching your goals, a journey of achieving something you may have never dreamed of before, such as improving your legal skills, such as gaining advocacy skills, such as being able to speak fluently in English when this is not your first language. So there are really a whole range of skills, and there's a lot of knowledge that every single participant, I'm convinced, has been gaining in preparation for this pre-moot. And this truly makes all of you winners, even if only one single team can be the winning team, as we say. But as I'm pointing out here, don't see this narrowly, really see this in a broad sense, and be proud of yourself. See this as the beginning of a journey of continuous improvement and continuous learning, continuous approach and journey of reaching your goals and of becoming better on your way on becoming a lawyer. Ideally, and I say ideally because this is my profession, an international arbitration lawyer. I cannot hide the fact that I very much like what I do. So this is why I say ideally an international arbitration lawyer. But of course, ultimately, it's up to every one of you out there to choose her or his career path. What you learn in the course of this competition is going to help you. And this is just what I mentioned. In addition of the knowledge and skills, above all, it is the perseverance. You keeping learning, you keeping practicing, even though you would probably like to go out with your friends, you would like to watch TV, you would like to be on social media, but instead you spend many hours, and not just hours, but many dozens of hours on preparing and on practicing. But as much as you had to bring sacrifice, really, as I say, this is hopefully the beginning of a very long journey. And trust me, on the long run, this is certainly gonna pay off. With that, congratulations once again to every single participant of this competition. And I close this with once again thanking the organizers for having me. Thank you very much. Come on.
Thank you for your expressive words. Now, ladies and gentlemen, coming to the main part of CIG Premier 2022, I'd like to present the two final teams, which is Team MMA and Team 1900. I'm sure all our viewers cannot wait to learn more about them. So may I ask the two teams some questions? Starting with Team 1900, would you introduce yourself to the audience?
Am I audible, the organizing committee? Yes, thank you, the organizing committee, for organizing such wonderful competition for us to, and for the law students in general, to practice their skills and to enhance themselves. And my name is tuyen, and with my co-counsel, Ms. Mỹ Duyên, we are Team 1900 from Ho Chi Minh City University of Law, and we appear today on behalf of the claimant. Thank you.
I bet that many viewers are also curious about your team's name, and so do I. So either hidden meaning about the name 1900, can you share about it with us?
Well, thank you for such an interesting question. It was actually an interesting story behind that, because firstly, our team has 4 members, and the number 1900 was taken according to the last number of each member years of born. And because we have 1 member was born in 1999, 2 members in 2000, and 1 member in 2001. So we have the last number of the years. But unfortunately, 1 member was having some problem, and she cannot continue with us. So that is the story behind our team names. Thank you.
Thank you, Team 1900. And now Team MMA, I also have some question for you. I'm also curious about your team name. So may I ask what MMA stand for?
Okay, so good afternoon to all our guests and our law students. My name is Đào Linh Chi, and I appear on behalf of the respondent on this hearing with my co-counsel, Đặng Anh Phúc. Yes, and as you asked, many people are curious about our name, MMA, and actually they are often like mistaken with the mixed martial arts, but MMA actually stands for Masters of Mystic Arts. This indicates the way we form our team is like by all the accidents, and it's like the signal of the universe that bring us all together, and that's why we chose the name MMA, which stands for Masters of Mystic Arts.
Well, thank you. Now I get it. Here is another question for you. I heard that your team and the opponent, Team 1900, has encountered each other at the preliminary round, and now you're about to compete again in the final round. So it seems that the two teams had quite disdain for each other. Do you guys have anything to say to the opponent before we entering the final round?
Okay, so I will start first. It is actually like quite a chance to see the opponent team again, but I actually expected that from the first time I saw them on the elimination round, because I see that the councils, the opposing councils are really good, and after the elimination round, our team actually had one very strange dream that we dreamt of the scenario in which we and the 1900 teams encountered again in the final round, and yeah, it actually happens in real life.
Thank you, Ms. G, for your confessions. And actually, we also on the same page about that. Since we first have a match with your team in the eliminator round, we was truly impressed by your performance because it was so good. It was truly impressed us, and we also have a thought that maybe someday we can have a match again, and we can share the knowledge and the skill together to improve ourselves. And I guess that scenario is here. So whoever win this match, I think that we are both worthy for this, and I'm really grateful for having a match with you again.
Thank you both teams for that very interesting exchange. On behalf of the organizers, best wishes to all the contestants. So now, with no further ado, I'd like to announce that the Vietnam CIG Premier 2022 final match has officially started. Before we get to the rules, I'd like to have you all take a quick look at the synopsis of questions by the following video. I suppose that our two teams are already clear of the problems of the competition. And now, on behalf of the organizers, we'd like to announce the ultimate rules for the final round of Vietnam CIG Premier 2022. First, in principle, each team will have a sum of 30 minutes for their presentation and 15 minutes to answer questions from the tribunal, making a total of 45 minutes. The final hearing is supposed to last for 90 minutes. There are 2 oralists for each team in this round. Each team should allocate a given amount of time equitably for the 2 advocates. However, the time for the arbitration tribunal may exceed the given time limit so long as neither team is allowed more than 45 minutes, including the time to answer the questions from the tribunal. Second, the arbitrators will decide if the rebuttal arguments will be permitted. And third, both teams are not restricted to their arguments in the written outlines. In my hand right now is the drawing result for the final match today. Let's find out who will be in charge of certain roles. I'd like to announce that Team 1900 will be the claimant and Team MMA will be the respondent for the final match of Vietnam CIG Premier 2022. May I ask the 2 teams whether or not you understand clearly the rules and the duties of the game?
Yes, we understood.
Yes, we understood.
If there isn't any question, I will assume that the 2 teams have fully understood the rules. I would like to invite the tribunal to start the hearing procedure and shall the game begin.
Thank you very much to the organizing committee. Before we start, I have a quick question though on the procedure. Is there anyone from the organizing committee who will be taking a note of the time, or is that entirely up to the tribunal? Okay, no answer. So I'll assume that the tribunal will do that. With that, I open this hearing, the final rounds of the Vietnam CISG Premoot between 1900, which stands for, as we just learned, 1999, 2000, and 2001, as the claimant, and MMA, not mixed martial arts, but rather the Masters of Mystic Arts, as the respondent. As the chairperson of this hearing, it's my great pleasure to welcome both parties to the hearing, having carefully studied their written briefs also. I'd like to verify with the teams if there are any preliminary issues they would like to address before we formally start. I first turn to the claimant.
Mr. President, we don't have any other issues, but we just want to clarify that we have an agreement on the time allocation for the bleeding. Specifically, each team will have 13 minutes for presenting the arguments and 2 minutes for rebuttal and 2 minutes for the third rebuttal. That is our agreement.
Counsel, thank you very much for noting that. You forget, however, the second rule that was shown on the screen, which is the arbitral tribunal will decide whether there will be rebuttal or not. So you are assuming that the tribunal will allow rebuttal. We haven't confirmed that at this stage. So let's follow the procedure, please. Although I'm grateful for you pointing out this agreement, Let me first please turn to the respondent. Could respondent kindly confirm first the agreement and also indicate whether there is any preliminary issues the respondent would like to address?
Yes, indeed, Mr. President. I confirm that it is actually our pre-agreement in this oral hearing. However, as you previously said, we should first follow the procedure given by the organization committee, and I believe both parties respect that. And secondly, I think we up to now we have no preliminary issues to be clarified.
Okay, thank you very much. Could I then turn to my two colleagues, please, and may I invite you to get your views on the proposal, I should say, by the parties to have rebuttals. Do you have any views on that, or and in particular any objections?
Mr. President, I have no objection.
Thank you.
I have no objection. Thank you, Mr. President.
Okay. Thank you very much. In light that there are no objections from my colleagues and neither from my side, I think what we must keep in mind here is that arbitration is all about party autonomy, and the rebuttal and surrebuttal are part of how arbitration works, also in real life, at least to some extent. And I believe it's absolutely the correct decision to follow the parties' agreement. So we'll be very happy to go with the 13 plus 2 schedule, if you want to say so. Could I please just clarify one more time with the parties? It will be 13 plus 2 for all 4 speakers. Is that correct?
It is actually for each council, Mr. President. Each council will have 13 minutes for presenting and 2 minutes for rebutting.
Yes, that's what I understood. And I saw some nodding from the claimant, so I take this as a yes. Great. Have the parties any proposal on the order of the arguments? I will ask the claimant first.
Yes, thank you, Mr. President. We propose that for the procedural issues, the respondent will present first, and then the claimant, and then the rebuttal from the respondent, and then the third rebuttal from the claimant. And for the merits issue, the claimant will present first, and then to the respondent, and then so on, the rebuttal and third rebuttal.
Thank you, Counsel. Is my understanding correct that your proposal is also to start with the procedural issues? Okay.
Mr. President.
Okay, sorry, I saw some nodding, so I just took that as a yes. Thank you, Counsel. Could I ask the respondent as well, please? Can you agree to the claimant's proposal? You know, let's make this quick.
Yes, we agree.
Okay. Could I again, thank you, Counsel. Could I again please briefly check with my two colleagues, any objections to this proposal?
Mr. President, no objection from me. Thank you.
Thank you.
No objection from me either. Thank you, Mr. President.
Thank you very much. I also have absolutely no objection. I think that's the normal way to go. And it makes sense because you first want to determine whether there is jurisdiction before you go to the merits. Although, as you know, of course, the rules of the Wiesmoed do not stipulate that it has to be this way. So some people take the view that just to confuse the opposing team, it makes sense to propose to go a different way, but that's for the future. Great. Now that we've clarified all the preliminaries, if there is no point or question or comment from anyone, and I don't see anyone turning on his or her microphone. So I take this as a yes, that there are no further preliminary points. I invite the respondent to start with its presentation. I again invite you, you have 13 minutes, and we received a message from, or I received that from the organizing committee, that the organizing committee will take care of the timekeeping. So we will not be super strict, you know, this is not a chess clock arbitration, but keep in mind that time management is one of the factors that affects your score. So keep that in mind. And counsel for respondent, whenever you're ready, you have the floor.
Yes, I am ready. Thank you, President and arbitrator. I will begin my presentation. Member of the tribunal, greeting of the day. My name is Dang Phúc, and I'm appearing with my co-counsel, Mr. Linh Chi, on behalf of the respondent of this arbitration. I will present the respondent agreement on the jurisdiction issue. Member of the tribunal, the arbitration agreement is the heart of the arbitration. The jurisdiction of this arbitration tribunal to settle the dispute depends on the validity of the arbitration agreement. In the present case, it is the respondent's submission is that there is no valid arbitration agreement according to the applicable law. I shall present three arguments, which correspond to issue A, 1, and 2 of the prosecutor order number 1. First, the law governing the arbitration agreement is meritorious. Second, the CIT applies to the arbitration agreement. And 3, the arbitration agreement is invalid under applicable law. Before I present my argument, I would like to ask the tribunal to turn to page 32 of the record. Is the tribunal still with me? Okay, this respondent exhibit number 4. I would like to clarify first and foremost that the arbitration agreement I will be addressing through my whole presentation is Article 9 of the General Condition of Sale after the change in 2016. Turning to my first argument, I would like to make 2 submissions. First, Danubian is a seat of arbitration, and second, the law governing the arbitration agreement is meritorious. For my first submission, as will be provided by my co-counsel when she presented at the merit of the case, neither the conclusion of the 2020 contract nor the inclusion of the General Condition of Sale into the contract is valid. This means there was no agreement on the choice of the seat of this arbitration, and thus the legal framework to govern this arbitration as a whole is in question. Since both parties—
Counsel,
yes,
I assume you are familiar with the separability principle.
Yes.
So, counsel, the separability principle states that the arbitration agreement is separate from the main contract. If I understood you correctly, your argument was just now that because the main contract is invalid, so is the arbitration agreement.
Yes, I will explain my approach on the arbitration agreement according to the doctrine of separability later. Is that okay, Mr. Arbitrator? Thank you. Since both parties only choose the ICC rule to be the procedural rule for the arbitration, under Article 14 of the ICC rule, the tribunal shall decide the seat of arbitration which consider being appropriate based on the circumstances of the case. In the according to Simon Greenberg and Christopher P., they have suggested 3 most important criteria must be taken into account to determine the appropriate seat of the arbitration. Those criteria are: first, the seat should be a party of the New York Convention. Second, the seat of arbitration law should provide the desired level of judicial interference. And third, the neutral of the seat should be met. The requirement of the neutral of the seat should be met. In this case, Danubian has met all the requirements to be considered an appropriate seat for arbitration. Therefore, I respectfully request the tribunal to choose Danubian as the seat of this arbitration. Turning to my second submission, by applying the Danubian arbitration law, the law governing the arbitration agreement shall be maritarian. As the law of the seat of the arbitration, the Danubian arbitration law shall govern the arbitration proceeding. Under Article 28A of Danubian arbitration law, the law governing the arbitration agreement shall be determined by, first and foremost, the agreement of the party. It is the respondent's submission that the party have implicitly chose a law of maritime law to govern the arbitration agreement. This choice is demonstrated by two factual points. First, based on the party communication, and second, based on the history of Article 9 of the General Condition of Sale. For the first point, may I direct the tribunal to page 10 of the record, which is Mr. Chandra's statement. Is the tribunal still with me? Okay. In paragraph 13, Mr. Chandra said that the contract shall be governed by the law of maritarian. Corresponding to the choice of law made by the claimant, the respondent has said such a choice, demonstrated by Ms. Bubati's email on page 12 of the record. In the paragraph, begin with the following sentence. Following our discussion. As you can see, member of the tribunal for commercial.
Sorry, counsel, can you be more specific, please? Because I lost you lost me. Paragraph 13 has about 12 lines, and you also made reference to page 12. Could you be more specific, please?
Okay. May I have 5 seconds to turn to the page? On paragraph 5, on paragraph 13 of the witness statement of Mr. Chandra, on the 1, 2, 3. On the third sentence of the paragraph, begin with the furthermore, I ask you to point out that contrary to our practice. Okay, turning to my next point is Ms. Bubati email on page 12 of the record. In the paragraph, begin with the following our discussion.
Sorry, this is, you said paragraph 12 or page 12?
Page 12 of the record.
And which paragraph?
The paragraph begin with following our discussion.
Okay, thank you.
Okay. As you can see, member of the tribunal, for commercial party that did not separate the arbitration agreement from the sale contract. This means that the party want the whole legal relationship to be governed by the same law. Therefore, based on the conversation between the party, it does indicate that the intention is to choose maritime law to govern the sale contract, sale as a whole, even the arbitration agreement. It is also supported by my second point. May I direct the tribunal to paragraph 24 of page 51 of the record. Is the tribunal still with me? In the previous version of the General Condition of Sale, it contained a choice of law clause separated from the arbitration agreement. However, after the dispute between the claimant and
counsel, again, paragraph 24 has 15 lines. You need to be more specific, else the tribunal will not be in a position to follow you.
It begin with at the same time, it includes the choice of law clause in favor of Danubian law contained until then in the Article 9 list of the General Condition of Sale into the new Article 9 of the General Condition of Sale. Did you locate it? Did you locate the sentence, Mr. Arbitrator? Thank you. After the dispute between the claimant and the Southern Commodity in 2014, the claimant has merged the choice of law clause into the arbitration agreement. This also demonstrates the intention of subsequent choice of law clause to extend to the arbitration agreement. These 2 points is in line with the decision in the case of Enka, which is judged in the Royal Court of Justice in April 2020. The court faced an issue similar to the present case. whether the law applies to the underlying contract or the law of the seat will govern the arbitration agreement. Consequently, it was held by the Honorable Judge Mr. Andrew Powell that it can be presumed that if the party had chosen the law to govern their contract, they would have made an implied choice of the same law to govern the arbitration agreement.
Counsel, since you mentioned the judge by name, was the judge the only person who decided?
No, Mr. Arbitrator.
Okay.
I will continue. Therefore, in the present case, by choosing the law of maritime law to govern the main contract, the claimant and the respondent have made an implied choice of maritime law to govern the arbitration agreement. I will now turn to my second argument, which is the application of the CIT.
Counsel, before you go there,
yes,
was there any lawyer involved in setting up the contract?
I'm sorry, can you rephrase your question?
Was there any lawyer involved in setting up the contract or during the contract negotiations?
During the negotiation of the contract, the in-house counsel of claimant setting out the contract. They prepare the contract.
Okay, so on one side there was an in-house counsel.
Yes.
Okay, do you think that this in-house counsel and the counterparty, from the other side, are sufficiently knowledgeable of international arbitration to distinguish between the law governing the substance and the law governing the arbitration agreement?
There is no, I'm sorry, Mr. Arbitrator, but there is no fact to provide that
in the problem, yes, I appreciate that, but I'm asking you, based out of experience, there's an in-house counsel who's dealing with a plethora of issues, of legal issues, not just arbitration. And on the other side, we have someone who is not even a lawyer. Are those people going to be sufficiently knowledgeable to distinguish those issues you just pointed out?
Yes, Mr. Arbitrator, I agree with your situation. However, in this case, maybe the in-house counsel of the claimant maybe have forgotten, or they have not done a good job to separate the arbitration agreement, to point out the proper law to govern the arbitration agreement.
Well, I think it happened because they're simply not sufficiently sophisticated.
Yes, okay.
So how can we assume that there is an implied choice if they cannot even distinguish? How can we assume that there is an implied choice?
Because Mr. Arbitrator, the choice is made during the negotiation between the party only, not between.
Counsel, how can you choose something if you don't even understand what you're talking about? Is that possible logically?
They know, Mr. Arbitrator, I think they are really aware of the situation they are in, because they have concluded multiple contracts before. They have applied the arbitration agreement. They know that they are doing the law to govern the contract.
They maybe know the law governing the contract, but what about the law governing the arbitration agreement?
The party, in my presentation, I have made it clear that the both party, both representative of the party doesn't know about the separability of the arbitration agreement. Sorry, because since my time is progressing, may I continue with my presentation by adding for 3 minutes.
Your time is actually up, Counsel. We just got a message from the Secretariat. Are you seeking an extension?
Yes, I am asking for the extension time to conclude my argument.
Okay, for how long?
I would like the tribunal to provide me 4 minutes to conclude
4 minutes.
my argument. Yeah.
Okay, good. That's quite long. So I will be asking my two colleagues on their views.
I think 4 minutes will be a lot. You should try to conclude it within 2 minutes. That's my view. Thank you, the President, for asking.
I also agree, Mr. President, that is sufficient make up for the discussion between the presidents and the council. So I agree with the position of 2-minute extension. Thank you.
Okay. Thank you very much to my two colleagues. Then Council, you have 2 more minutes, and to the organizing committee or the secretary, please start taking the time from now. Thank you.
Okay. Member of the tribunal, I will now turn to my second argument, which is the application of CIT to arbitration agreement. In light of that, I would like to make 2 submissions. First, the arbitration agreement in this case exists only in the form of a contractual clause. And second, a CIT governs the arbitration agreement in the form of a contractual clause. Regarding the first submission, the arbitration agreement we I had mentioned earlier is provide only into the general condition of sale and not in the sale contract. Throughout the negotiation stage and the dispute, both parties did not enter the conclusion of a separate agreement on the dispute resolution. This means the intention of the arbitrate of the party is only exists in the arbitration clause contained in the general condition of sale. Furthermore, I would like by the content of the contract, the arbitration agreement, the term contract only makes sense if the arbitration agreement refers to a specific contract by being a contractual clause. Therefore, in conclusion of my my first submission, the arbitration agreement cannot exist in another form of contractual clause. Turning my second submission, the CIT is applicable to conclusion of the arbitration agreement. Since maritime law is a contracting state of the convention, the CIT is part of the national law of maritime law. And to my first argument, the maritime law govern the arbitration, the contract as a whole. Therefore, the CIT also govern the arbitration agreement in the conclusion of the agreement. Turning to my final argument, respondent would strongly argue that the arbitration agreement is not valid. As I have mentioned, the arbitration agreement exists in the form of a contractual clause. Therefore, the arbitration agreement becomes effective in the form of a contractual clause only when the general condition of sale is validly included in the sale contract, and that contract is validly concluded. This argument will be presented a member of the tribunal. It is the respondent's submission is that the general condition of sale were never validly included in the sale contract, and both parties have not concluded in the sale contract. This argument will be presented by my co-counsel, Ms. Darling Chi, when the tribunal deal with the merit of the case. And thus, drawing from her argument, the arbitration agreement is not valid in the form of contractual clause. Thank you for listening.
Okay, thank you very much, counsel. You were lucky because I was about to stop you since you went beyond the 2 minutes. Yeah. But I think a few seconds are okay. As I pointed out, this is no chess clock arbitration. Thank you very much. Can I please, before we move on, can I please verify with my 2 colleagues once again whether they have any questions to the council? Any questions at this point?
Thank you, Mr. President. I have just one question for the respondents' council. I'm still struggling to understand why you need to rely on the law of the seat with a very lengthy discussion and submission to try to determine the law governing the arbitration agreement. I thought the arbitration agreement as you submitted has been agreed in some form, implied or whatever by the parties. Why you have to go back and try to prove the other submission? Thank you.
Okay, thank you, Mr. Arbitrator. It is in my presentation, I have concluded that the arbitration agreement is existed in the form of contractual clause, and it must go. And it is subject to it must concluded through the inclusion of the general condition of sale, and the sale contract is validly included. Therefore, the agreement between the parties to arbitrate to give rise to the jurisdiction of this tribunal must depend on the validity of the arbitration agreement. However, it is the respondent's submission that the general condition of sale has not been validly included, and the sale contract has not been concluded. Therefore, there is no agreement on the choice of seat and the arbitration agreement, and there is no choice of seat. That's why I want to present my argument on the choices on the seat, Mr. Arbitrator.
Thank you, Counsel.
Any additional questions from my colleagues?
Mr. President, I would like to ask my questions after the claimant argumentations. So after this.
Absolutely. Thank you very much. Thank you for clarifying. Great, then Counsel, thank you once again. Your explanation certainly helped the arbitral tribunal in understanding your position better. With that, we move on to the claimant. And you also reserved 13 minutes for your presentation and 2 minutes for rebuttal. So claimant, whenever you're ready, the floor is yours. Thank you.
Thank you, Mr. President. Members of the tribunal, counsel for respondent, good morning or good afternoon, depending on where you're at. My name is Tuyen, and as I have introduced, I will now be addressing the jurisdictional issues on behalf of the claimant. Members of the tribunal, trust is the glue of life. It is the most essential ingredient that holds all the relationship and the keystone of business. Along with that, consistency is the true foundation of trust. Either keep your promises or do not make them. In the case at hand, claimant and respondent have had a long-term business relationship. The contract here was concluded based on an understanding of the previous practices between the parties. However, after being influenced by untrustworthy information and a fear of bad publicity, the respondent unilaterally terminated the contract and avoided all the responsibility, betraying claimant trust and breaking a long-term business relationship. And with that, I will now begin addressing the procedural issues. We submit that the tribunal has the jurisdiction over the dispute for two reasons. First, the law governing the arbitration agreement conclusions is the Nubian law. And second, the law of Mediterranean cannot be applied here, but applying the Nubian law, the arbitration agreement has already been concluded. Starting with our first submission, we submit that the law governing the arbitration agreement is the Nubian law according to the seat of arbitration, and the law of Mediterranean cannot be applied. First, if I may direct the tribunal to page 32 of the problem. This is the general condition of sale used for the contract. And as the opposite counsel has stated in Article 9, which is the arbitration agreement, the fourth line states, the seat of arbitration is the Nubia. And furthermore, when determining the law applicable to the arbitration agreement, there is a three-step test that need to be applied. The first step is whether or not there is an express choice of law to do so.
Counsel, what test is this? Is this just your idea?
Yes, Mr. President, we based on the case BNA versus BNB in Singapore in 2019.
Okay.
Yes.
Sorry, which court was that?
It's the Singapore Court of Appeal.
Okay, thank you.
Mr. President, may I proceed? Yes. So again, back to the three-step test. Applying the first step, there has never been any express agreement or saying of the parties that which law will be used to govern the arbitration agreement. Therefore, we move to the second step, which is the implied choice of law of the parties' intention. And in this case, by indicating that the seat of arbitration is the Nubia, the parties have implied their choice that the Nubian law will also be used to govern the arbitration agreement, which was stated in the case First Link Corporation versus GT Pavement in Singapore in 2014. More specifically, Article 5.1.8 of the New York Conventions also directly leads to the application of the law of a seat of arbitrations if the parties have no other choice of law expressed by them.
Council, the New York Convention, it deals with the enforcement and recognition and enforcement of arbitral awards, right?
Yes.
But we are now, there is no award yet. So why should we apply something that applies to the recognition and enforcement of awards?
Yes, Mr. President, I understand your concern. Although in its word, the New York Convention mentioned the enforcement of the reward. However, this is the direct consequence of the formations of the arbitration agreement at the very beginning.
Thank you.
Yes, thank you, Mr. President. I will now proceed. Therefore, as the tribunal can clearly observe, the parties have agreed that the seat of arbitration is the Nubia. Therefore, the law governing the arbitration agreement is also the law of the Nubia. And second, counsel for respondent may attempt to convince the tribunal that because the arbitration agreement is under the main contract, therefore, the law governing them must be the same as Mediterranean law. However, we submit that the law governing the arbitration agreement cannot be Mediterranean law. Firstly, because applying the doctrine of separability, the arbitration agreement is separate from the main contract, allowing the tribunal to hold a case even when the main contract is void or is invalid. And applying and approach this doctrine in a broad sense, the arbitration agreement and the main contract is separate in a sense that the laws governing them can be different. And as we have submitted, there is already a law that will be used to determine the conclusions of the arbitration agreement, which is the Nubian law. Therefore, there is no place for Mediterranean law to be applied here.
Counsel, does the doctrine of separability state that we must always completely distinguish the main contract and the arbitration agreement, in the sense that if the law of the main contract is A, then the law governing the arbitration agreement must be B, unless there is an explicit choice? Is that your submission?
No, Mr. President, our submission was, under this doctrine of separability, there is a possibility for the main contract and the arbitration agreement to be different. We don't submit that there must be a difference, but there is a possibility for them to be different. Which
but then there's also a possibility for them to be the same, right?
Yes, there is a possibility for them to be the same if there is no choice of the law governing the arbitration agreement. But in the case at hand, there has already been that law, which is the Nubian law. May I proceed, Mr. President? Yes, thank you. Moving to our second submission, applying the Nubian law, the arbitration agreement is valid. If I may direct the tribunal to page 47 of the problem. This is the procedural order number 1. The 7 lines state that the Nubian law adopt the option 1 of Article 7 of the Ancestral Model Law. We submit that under option 1 of Article 7 of the Ancestral Model Law, the arbitration agreement is fully concluded because the only condition is met. Specifically, according to Article 7.2, the arbitration agreement shall be in writing, and the definition of in writing is also interpreted as the content is record in any form. In a case at hand, obviously, the arbitration agreement is in writing because its content is record in Article 9 of the General Condition of Self. Therefore, the element in writing is met and the arbitration agreement is concluded. And the tribunal, therefore, shall have the full jurisdiction over this case. And turning to our last submission, even if the tribunal held that the arbitration agreement is governed by Mediterranean law, the CISG is not applicable to the conclusion of the arbitration agreement here. Yes, the claimant and the respondent have their place of business in Mediterranean and Equatoriana, which are the members of CISG. However, CISG is not applicable here because the issues related to the arbitration agreement cannot be governed by CISG. First, The scope of application of CISG include the formation of a contract, the rights and obligations of a seller and buyer, which is stated in the Article 4 of CISG. We submit that the arbitration agreement is not under either of them.
Council, I'm a bit puzzled. Aren't we discussing whether I mean, it's one of the issues, right? Whether the arbitration agreement was formed validly. So isn't that the formation of a contract like the CISG mentions?
Yes, Mr. President, I will now address that. The formation of a contract deals with the offers, acceptance, and the consent of the parties. However, the arbitration agreement is merely for the purpose of dispute settlement after the contract is formed, not at the stage of forming a contract. Therefore, we submit that it is not under the scope of forming a contract.
But Council, doesn't the separability doctrine make it clear that it is a contract of its own, if you want to say so?
Pardon me, can you restate your question again?
Sure. The separability doctrine, it makes it clear that the arbitration clause in a contract is a separate agreement. So we can say it's a contract of its own, can we not?
Dear Mr. President, in our position, we don't agree that the arbitration agreement is a different and a separate contract. It is a document separate from the contract, but it's not a contract on its own. It supports the main contract. May I proceed, Mr. President? Yes, and after denying the formation of the contract scope, we turn to the rights and obligations of the seller and buyer. It is obvious that the arbitration agreement does not exclude the parties from any substantive duties or assign them any arising ones from the contract. But again, it was just to serve the dispute settlement procedure. Therefore, the issues of arbitration agreement are not under both scope and obviously not under the CISG scope of application. More evidently, in the case Italian Textile 2 in Germany in 1996, the questions of concluding the arbitration agreement is held to be outside of CISG scope of application.
Council, which court was that?
Pardon me, can you restate again?
Which court was this? Which German court?
Yes, it was the German High Court.
Okay, can you be more specific? Like High Court of what? There is no such thing as the German High Court.
Thank you, Mr. President, for your questions. As the information that we only got at the German High Court, so we may check the information again and then we can confirm with you.
Okay, now let's proceed.
So I see that I have 1 minute left, so I will now briefly move on to my second point. The arbitration agreement is a procedural agreement. It can only be governed by procedural laws. On the contrary, CISG is considered as a substantive law, and a substantive law cannot be used to govern procedural issues. Therefore, CISG is not applicable to the conclusions of the arbitration agreement. To conclude a procedural issue based on the application of Danubian law, which led to the conclusions of the arbitration agreement, we request the tribunal to find that the tribunal has the full jurisdiction over this case. If there is no further access needed, I rest my case. Thank you.
Thank you very much, Council. I'm again, first and foremost, verifying with my two colleagues whether they have any questions at this point.
Not from me. Thank you, Mr. President.
Yes, I will also save my questions after the rebuttal. Thank you.
Mr. President,
yes.
I have only like 5 seconds to answer your previous question about the what court in the
Okay, please do. I'm curious.
Yes, thank you. We confirm that that court was the German district court. In that case, Italian text title 2 that we are referring
Okay,
to.
I'm sorry, counsel, but the German district court also does not exist. It doesn't matter whether you call it high court or district court. It's supposed to have a specific name, but I appreciate it was at that level, so that's okay. Thank you. Counsel, I have an immediate follow-up question. Towards the very end, you said the CISG is a substantive law, and as such, it cannot govern the arbitration agreement, if I understood you correctly.
Yes, it is,
Yes.
Mr. President.
So counsel, just to clarify, is it your position that what you just said applies specifically to this case only, or is this a general rule? And the general rule would be the CISG can never apply to the arbitration agreement.
Actually, Mr. President, our position is that the CISG does not apply to the dispute settlement procedure, and more specifically, the conclusions whether or not the arbitration agreement has been concluded. It just governs the substantive issue of the contract. Yes, Mr.
Sure,
President.
I understood that argument, but my question is, what you say, does this apply only to this case, or is it a general principle?
Yes, Mr. President, we believe that this is a common admit, because it was also held in the other case in the international scope, which is the Steel Bar fourth case in Germany in 2002.
Right. Okay, I understand. Thank you very much.
Thank you, Mr. President.
That brings us back to the respondent. Respondent, you reserved 2 minutes for rebuttal.
Yes.
So whenever you're ready, the floor is yours.
I would like, thank you, Mr. Arbitrator. I would like to make 4 points for rebuttal. The first point regarding to the implied choice. In the last sentence in paragraph 15 on page 50 of the record, based on the confirmation of the claimant outside counsel, Mr. Langweller, the intention of the party when they choose Danubian is a seat of the arbitration is merely based on the arbitration-friendly environment in Danubia and the supportive attitude and the experience of the Danubian court. This means there is no extent that the party that made an implied choice on the law governing the arbitration agreement by choosing Danubian as a seat of the arbitration. From the second point, on the broad view of the doctrine of severability, as I mentioned in my presentation, the intention to arbitrate it of the party is only exists in the arbitration clause contained in the general condition of sale, which is Article 9. Furthermore, in the first line of the Article 9, the term it contains the term "this contract." This term only makes sense if the arbitration agreement refers to a specific contract by being a contractual clause. Therefore, the arbitration agreement in this dispute cannot exist in any other form than a contractual clause, which means the arbitration agreement must be approached under a narrow view. In my third point, despite if the tribunal decide in favor of the claimant that the law applicable to the arbitration agreement is Danubian law, then I will apply the claimant counsel position is that the arbitration agreement is entirely separate from the main contract. Such agreement will be invalid since it not meet the writing requirement. According to Article 7 of Danubian arbitration law, there are writing requirements for the arbitration agreement. However, the arbitration agreement in a separate contract only presented by the respondent by the claimant through the telephone, which means the writing requirement of the arbitration agreement has not been met. This marks the end of my rebuttal. Thank you.
Thank you, counsel. Are there any questions from my colleagues now, or would you rather wait until the very end? Yes, okay. Thank you very much. Then we move again back to the claimant. Claimant, you also reserved 2 minutes for your rebuttal. So whenever you're ready, please start. Thank you.
Thank you, Mr. President, and thank you, counsel, for responding for your rebuttal. I would like to have 2 points to make in my rebuttal. First, we submit that the the understanding of the arbitration agreement in the doctrine of severability should not be understood in a narrow scope as the respondent stated, but it should be understood in the broader approach, which allow them to have different laws governing them. And this would also state in the case C versus D in the UK in 2007. And second, you mentioned the Council for Respondent mentioned that the writing element of the arbitration agreement is not met because Ms. Bubati was only received that on a phone call, the change of the arbitration agreement on a phone call. However, this would later be addressed by my co-counsel in the merits issues that the parties here have exists a practice that if the claimant sent the document to the respondent and the respondent didn't sign back or have any written acceptance back, it would still be conducted. And applied to this case, the general condition of self has been revised in 2016, and the old version has already been used between the parties, and the only change in the new versions has already been informed to the respondent via telephone, and there was no objection raised. Therefore, we suppose that the respondent has full awareness of the full content of the new versions of the arbitration agreement and raised no objections. Therefore, they have the consent here, and the element of concluding the arbitration agreement is met. This marks the end of my rebuttal. Thank you.
Thank you very much, Counsel. We are not letting you go yet because now you will be bombarded with questions, I hope, from my two colleagues.
Thank you, Mr. President. I would like to have one question for respondents counsel and another question for claimant counsel. First of all, one question for respondent counsel. So after I hear the argumentation back and forth between your side and the other side, we understand that it is important to determine the procedure, but based on the substance issue as well, because among other things, we need to consider the validity of the general condition of sale and the inclusion of this document into the sale contract. So let's say, assuming that the arbitration rule applicable allowing us, we would need to determine whether we decide the procedure matter now or we wait until we combine the substantive, the merit issues. And we would like to hear your opinion on these determinations. What is your positions and explanation?
Thank you, Mr. Arbitrator. It is our opinion is that we should present the merit first, then we will present the jury's issue, because the general condition of sale in our position is that the standard term which contain an arbitration agreement. The arbitration agreement has content that must be understood as a contractual clause rather than a separate agreement, which we present is must be approached in a narrow view. Then so it is much so therefore the incorporation of the general condition of sale must be the incorporation of the general condition of sale into the contract must be presented first. Then then the conclusion of the contract which present that both parties have reached an agreement in the contract which contain the arbitration clause. Therefore, they have reached an agreement that the seat will be Danubian and the jurisdiction of the IIC institution. Then we will move to the juries.
Okay. That's on your submission, right?
Yes, that is my answer.
Okay, thank you and noted. And I have one question for the claimant counsel. So in your argumentations, one of the submission is the formal requirement has been met. In particular, the writing requirement has been met. And you refer to the Danubian law. But in the Danubian law, one of the requirements is the document must be made in writing, I mean the agreement. must be made in writing. And in this case, it is uncontested fact that the document has not been signed and returned to you, to your side, and the general condition of sale has not been provided to the respondent side. So could you please clarify and explain why you consider with that uncontested fact that the formal requirement has been met?
Yes, Mr. Arbitrator, I will now address your concern. First, as we have submitted, according to the Article 7.3 of the ancestral model law, the element in writing can be integrated as the content is record in any form. And in the case at hand, it is record in the form of an article of the general condition of sale. And for the second point, although the unconstated fact mentioned that there has never been any official document sent to the respondent. However, we will base on the practices between the parties that if the claimant is sent, and if the respondent they have a full awareness of that arbitration agreement and they have no objections, then it should be applied and conducted. And again, in the case at hand, there is two versions of the general condition of sale, including the arbitration agreement. The one old versions before 2016 and the new versions with the change in the arbitration agreement. The old version has been used many times between the parties. Therefore, the respondent fully have aware of it. And the only change in the new versions was also informed to the respondent via phone call. And Ms. Bubati specifically fully has aware of that. Therefore, the respondent fully have aware of the whole content of the arbitration agreement without any objection raised. Therefore, the arbitration agreement here, following the practices between the parties, will still be conducted and remains effective.
Thank you, Council. Are you saying that a document supposed to be in writing can be supplemented by an oral discussions, telephone conversations, following up with the document in writings?
Yes, Mr. President. Sorry again, Mr. Arbitrator. We suppose that the element in writing can be integrated in the sense at the Article 7.3 of the ancestral model law, which is the content of it is record in any form, which is already in writing, and the other factors, which is whether or not the respondent object to it or consent of it, has already been proved alongside with that.
Okay, okay. And even with the fact that that document has not been provided to the other party, right?
Yes, even if the document has not been sent in the material substance to the respondent, they have already aware of it and no objections, therefore it will still be conducted.
Okay, thank you, Council. Mr. President, I have no further questions. Thank you.
Thank you very much. Are there any further questions from?
Sorry. May I ask permission from the President to ask two questions? Actually, I have three, but my learned friend, Mr. Chung, already asked the second question. So I will ask the respondent, because this point has not been raised by any party. I'm pretty sure you're aware of the competence principle in arbitration. We are supposed, this tribunal is supposed to make judgment on the jurisdiction independently, and we are struggled why the parties have agreed or implied some law in the submission of the respondent that actually kill the arbitration agreement and make it invalid. A very general principle is that as a tribunal, we want this to exist, and the parties, when they intend to have a dispute resolution, they will want it to exist. But in this case, it seems that the implication that you presented lead to the invalidity of that agreement. Can you explain or submit any point or arguments on that? So that's a question for a respondent. I will save my question for the claimant later.
Mr. Arbitrator, may I say that question for later?
It's up to the Mr. President. As you.
Well, I think you know, counsel, you can always address it in possible post-hearing briefs, but the tribunal will take a decision on the outcome of this match today. So if you don't address a point, it will certainly not be to your favor, to put it very diplomatically.
Yeah, I understand. Well, this because it's one of our submission in the merit. Because Ms. Bubati in his email, in her email, she wants non-industry related to govern to settle the dispute. Arbitration institution to settle the dispute. However, by the wording of the IAC, by the wording of the arbitration agreement, the IAC has not met the arbitration has not met the requirement from the offer of Ms. Bubati. Furthermore, our respondent will want to be put on the court to settle in the court. My answer.
So are you suggesting that if there's any dispute whether or not there's a validity of the main substantive contract, it should be addressed by a court instead of this tribunal? Mr.
Arbitrator, the 17th of the arbitration agreement we were trying to address, because the IRC is not in favor of the intention of the Ms. Bubati, according to her email, while ordering the issue, the arbitration issue during the negotiation stage.
Thank you. Thank you, Counsel. My question for the claimant is really on the point that the President already mentioned, but I'm still struggle to understand. The most beautiful thing about characteristic of the CSG, as many people have highlighted, is that it is so flexible. It can be applied in any situation that the parties, and in whatever manner that the parties agree or wish to use. It's like a less mercantoria, if you know what I mean. Because of that, it's hard for me to understand your position that CSG is strictly applicable to the substantive disputes and not for the procedure matters. If you can make any, if you can quote an authority specifying that clearly to convince this tribunal, I think it would please my concern.
Yes, thank you, Mr. Arbitrator. Firstly, the scope of CSG, yes, it could be understood in many approach. Depends on how the court analyze it and reason it. However, we base on a legal basis of case Stillbar 4 in German in 2002. It states that CSG as a substantive law cannot be used to govern procedure issue. Specifically, the procedure issue here is the conclusions of the arbitration agreement. Yes, the CSG, although it is flexible and is also mentioned the dispute settlement in some article of it, but it's only mentioned it in a very broad sense and not specifically whether or not the arbitration agreement has been concluded. And that is our submissions why it cannot be used to govern such procedural issues like the conclusions of the arbitration agreement. Does my answer satisfy your concern, Mr. Arbitrator?
Sorry. Yeah, I understand your point. And you quoted the German case of 2002. I'm aware of another case in Singapore. I cannot remember the year, but it seems that the parties' implied agreement go a lot beyond the scope of CSG, where actually relates to a service contract. And yet the tribunal in that case still agree to apply the CSG just because there was an intended agreement that the service can be applied to CSG. That makes some indication that CSG is not only applied in a strict sense of substantive and sales of goods disputes. It can be applied when the parties have the intention or implied agreement to use it. Do you have any like further authority or submissions to against that direction apart from what you have submitted?
Yes, Mr. Arbitrator, I just want to clarify and confirm again that upon the case that you are mentioning, if the parties have an agreement that they will use CSG to apply to the procedure issue, then it will be effective, that agreement. Am I correct on understanding that?
Yes.
Yes, Mr. Arbitrator. Then in that case, then applying to the dispute that we are referring to, the parties have never have any agreement that they will use CSG to apply to the procedural issues, specifically the conclusions of the arbitration agreement. And moreover, as this is our positions, there could also be other positions that mentions in other case. Therefore, this is not only our submissions to prove that CSG is not applicable. We also based on the main submission that the scope of CSG in its wording in Article 4 does not include the arbitration agreement.
Yeah, I understand. Thank you, Counsel.
Thank you, Mr.
I have no further question.
Thank you very much to both my colleagues. I think we have a little bit more time, so I also have one follow-up question, starting with the respondent. A very simple, basic question, and I ask you to not elaborate, but just to answer yes or no. And if you answer in the positive, then please provide the legal reason why you answer in the positive. So my question is, does this arbitral tribunal have the authority to decide, to determine the law that governs the arbitration agreement?
Yes, Mr. Arbitrator, according to Article 13.5 of the ISA rule, the arbitration tribunal have the authority to decide the law applicable.
Okay, thank you. Does the claimant agree with that submission?
Yes, Mr. President, we agree that the
okay.
Has the jurisdiction.
Okay, great. No, wait, it's not about, yeah, okay, you mean jurisdiction to determine the, yeah, okay, sorry. Then I go back to the respondent. If you apply Article 13 of the AIAC rules, then what standards govern the arbitral tribunal's decision?
Mr. Arbitrator, the legal framework govern the tribunal proceeding is the law of the seat, which means in this case the law of Danubian.
And what are the standards there for the determination of this question specifically?
I'm sorry, can you rephrase your question, please?
Okay.
So
my question is, I'm puzzled. You know, this arbitral tribunal has to take a decision. Now, we can take a decision. If I put it somewhat colloquially, I can say we can take a decision freestyle, or we look at certain standards that we have to take into consideration. And I would like to hear from the parties what these standards are.
Thank you, Mr. Arbitrator. On the legal basis, the standard 4 is prescribed in Article 28.28 of the Danubian Arbitration Law, which in this case the Unicitral Model Law, which prescribes the tribunal shall decide the dispute of the case by the law chosen by the party. And second, if the party have not chosen the law to govern the dispute.
No, counsel, sorry, I'm stopping you here because yes. you are telling me not the standards that must be applied to the decision, but you are highlighting in what case the arbitral tribunal should take a decision. But I'm wondering about the standards that should govern this arbitral tribunal's decision.
Sorry, Mr. Arbitrator, I don't have the answer.
Thank you, counsel. Could I turn to the claimant now? And the question remains the same. What are the standards that govern this arbitral tribunal's decision in determining the law applicable to the arbitration agreement?
Yes, Mr. President, as was submitted, in our position, the arbitration agreement is valid, and therefore the tribunal will have the jurisdictions here because the claimant submitted.
Counsel, I'm stopping you again. I heard you submit on that. This does not, it has nothing to do with my question. Again, let me repeat, and I appreciate it's not an easy question, but it's a question that would occur in real life, and this is why I'm putting it to both parties. So when you look at Article 13 of the AIC rules, and both sides are aware of it, it only says the tribunal has the power to determine the law applicable to the arbitration agreement. But what standards govern the tribunal's decision? Should we just take whatever we want to into account? Is it freestyle, or is there something that we are bound by, or we at least should take into consideration?
Yes, Mr. President, in our position, we submit that when the tribunal determines the law of the conclusions of the arbitration agreement here, there is no binding standards that they have to base on what, but they have to base on the sense and the persuasive and the proof that the parties submitted, and also the argument's soundness.
Okay, so if I understand you correctly, this is it's the same standards that would apply to any other regular question.
Yes, Mr. President,
okay.
We don't.
And when you speak of the proof, what if you could state it in percentages? How convinced should this tribunal be? Should it be, because the respondent basically makes the claim here that the arbitration agreement is invalid. So if we follow this claim, how convinced should we be? Should it be 100%? Should it be 90%? Should it be 50%, 30%? What should it be?
Yes, Mr. President, I suppose that I don't have the authorities to determine how convinced the opposing team's arguments are. And also I suppose that no one's have that authorities, and it depends on the decision of the tribunal. If I understand our question correctly.
Okay, no, it's okay, but let's leave it there. Thank you.
Thank you, Mr. President.
Okay, that brings us, we just got a message that there is only some time left, so we should move on rather quickly. This brings us to the merits, and we start this time with the claimant. So whenever you're ready, the floor is yours.
Yes. Good afternoon, Mr. President and members of the tribunal, and also the opposing counsel. My name is Ying, and as earlier my co-counsel introduced, I will address the marriage issue of this case. So starting with the third submission of our pleading, we submit that a contract was concluded between the parties. We have 3 points for this regard. First, respondent made an offer via Ms. Puberty email dated 1st April. And second, claimant made an acceptance to that offer by Mr. Rain's email. And third, in case Mr. Rain's email dated 9 April was a pertinent offer, that in that case, an acceptance from respondent still existed due to the practice established between the parties. Now, starting with our first point, under Article 14 CIHG, an offer requires 2 elements. First, the minimum contents about the price, quantity, and the kinds of goods. And second, the respondent must have the consent to be bound in case there is any acceptance. And if I may direct the tribunal to turn to page 12 of this problem. This is the purchase offer from Ms. Puberty, the representative of respondent. And as the tribunal can observe, all 3 minimum contents are met in paragraph 3. And once again, in this email, Ms. Puberty did express her delight when she would like to re-establish the relationship with Mr. Chandra as the first sentence in this email. For the intent to be bound by this offer, Ms. Puberty in paragraph 3 placed the following order, and therefore the word order is considered as a firm intent to be bound by the acceptance, and therefore, according to these facts, respondent made a valid offer.
Counsel, could you elaborate on the allegedly agreed upon price, please? Why it is sufficiently determined?
Yes, Mr. President, your question is about the price of the offer. Well, the price can be not definite, can be changed due to the market amendment, like there are changes in the market price, and therefore to prevent the dispute between the parties in advance, like maybe 2 or 3 years ago, there is a rise in the market price, and therefore in this offer, Ms. Puberty did warn first about the fluctuation of the price, and this gives the parties an easier way to discuss about the price and to perform the payment obligation later.
Okay.
And this is not.
Okay. 1 second. First, respondent 1, please mute yourself. Second, sorry for the interruption, but I just noted it. Second, counsel, what is the market price for palm oil?
Well, I believe the market price for palm oil.
Who determines what the market price is?
Well, the market price is illustrated in Climate Exhibit 3, the table in the page 13. So in this table, at the 4th row, it states that in the years number 2 and onwards, the market price, the price of the product will be the market price minimized 5%. And the person that determine the market price.
Counsel, how do we determine what the market price is? Who decides that?
Well, our position is that it depends on the demand and the need of the
customer in
Sure.
that.
But Council, let's move into the year 2025, okay? And how can I find out what the market price is?
Well, according to the notice of arbitration, to be honest, we cannot find the market price in page number 5. There is only about the favorable price offered by claimant in paragraph 5.
Council, your time is ticking.
Yeah, I'm sorry. For the second point, claimant did accept the offer, and if I may continue, direct the tribunal to turn to page 17 of the mood problem. The email dated 9 April. In the first paragraph, the last line, and I quote, "I have inserted the terms of the offer into the contract, which we accept." Under Article 18, Clause 1 CIHG, this statement is an acceptance by declaration, and therefore it can be seen that a contract was concluded. Moving on to the third point, if this email is considered to be a pertinent offer, we submit that an acceptance still exists based on two practices established between the parties. The first practice is not signing and not sending back the contract to claimant. And the second one is if there were any objection from Ms. Bubati to the contractual documents, such objection shall be raised within 1 week. Generally, according to CIHG Digest 2016, there are 2 elements for practice formation. First is the frequency, and second is the duration. And now we will compare whether those 2 factors met the requirement in these 2 practices. And for the first practice, 5 cases of not signing and not sending back the contract should be held sufficient. This was supported by the case Peter v. Spinneray Company in 1996, and the Netherlands District Court held that the repetition in 2 previous transactions was sufficient to create a practice. And moreover, in the tantalum powder case too, the Austrian Supreme Court in 2005, they also look at the frequency of those repeated behavior, not just focus on the total numbers of the contract between the parties. And regarding the duration, it was clear that the party relationships have initiated since 2010 and dismissed the element of during a certain period of time. And for the second practice, if I may direct the tribunal and the opposing counsel to turn to page 49, question 9. Line number 2 and 3, that among the contracts concluded, there were 3 cases where Ms. Bubati raised the objection to the contract document, and the time frame for raising the objection was within 1 week. So from this fact, it can be inferred that there is a practice of raising objection between the party, and in this case, Ms. Bubati did not raise.
Sorry to interrupt you. If I may, Mr. President, you just quoted the paragraph number 9 of that page. And at the same paragraph, I see that there are 2 occasions where it did not happen within even after a month. Can you explain this?
Yes, Mr. Arbitrator. In this question, there is an information that there was also time frame which she had sent back the signed contract, though 2 cases were happened after 1 month. Well, as I just mentioned, is about the frequency, not like about the percentage. that determine whether a practice existed or not.
Council, what do you mean when you say that it's about the frequency?
Yes, about the frequency of the contract, like it depends on how many times that conduct is repeated enough, sufficient enough to create the expectation for the other party that such behavior will be continuously applied into the upcoming contracts. That is the meaning of the frequency. Yes, may I continue? Okay, so from paragraph 9, it can be understood that there is no objection from Ms. Bupati, and therefore the contract was concluded. And moreover, in the contract as Climate Exhibit 3, it is number 41, which means that Mr. Chandra from Climate understand Ms. Bupati deadline when she wants to continue the long-term relationship there before, and therefore when respondent did not object the contract, and this is a illustration of the practice it still existed. And concluding all of them, furthermore, with the fact that respondent COO themselves, they approved this transaction, and it can be concluded that there was a contract between the party because there was an offer from respondent and an acceptance from claimant. And concerning the fourth submission, we submit that general condition of sales was validly included into the contract for 2 reasons. First, general condition of sales must be included, and it was included at the time of contract formation. And second, respondent was given a reasonable opportunity to take notice of these general condition of sales. I noticed that my time is running out. May I ask for only 1 minute to wrap this up?
Unless any one of my colleagues objects, I think 1 minute is fine.
Don't have any objection from me.
Thank you very much then. Yes, 1 minute.
Yes. The 2 points I've just mentioned was based on the rule 2 and 3 of the opinion 13 of CIHE Advisory Council about the inclusion of the standard terms under CIHE. So for the first point, that under the comment 2.6 in the opinion 13, although making the standard terms available is one approach to include the standard term into the contract. However, there is an exception that the standard term can be not available when there is prior knowledge about the contents of the standard term, which in this case is general condition of sales. And looking to the case at hand, respondent indeed had the knowledge about general condition of sales based on 3 facts. First, Ms. Bupati did receive the copy of the own version as stated in page 27. And second, about the new version, the amendment to the arbitration clause was informed by Mr. Chandra to Ms. Bupati. And lastly, the remaining contents of general condition of sales were unchanged, and therefore it can be concluded that respondent had prior knowledge about the contents of general condition of sales. And moving on to the other point, respondent.
Council, sorry, I have to stop you here because you are now beyond your 1 minute time extension.
Yes.
So I'll stop you here. Thank you very much. Are there any follow-up questions from my colleagues at this point?
No question from
Mr. President.
Okay, thank you very much. Then we move on to the respondent.
Yes.
You also have 13 minutes.
Yes, but before I present my case, can I seek for clarification on time allocation, please? I want to ask that does the 30 minutes for my presentation include the time for answering the tribunal's questions or not?
I think it's the tribunal's understanding of the rules that yes.
Yes, because as I remember previously, the rules set out by the organizing committee, the second rules points out that each council will have a separate 15 minutes to answer the question. So I want to seek clarification on that, please.
I was in fact raising your question with the secretary in a previous match during which I was sitting. And back then it was confirmed to me that the 15 minutes that each council has includes the time for answering questions.
Okay.
If that is not the case, and you know, first it was clarified like this, and I think, I mean, to my colleagues, please correct me if you have a different understanding. But in my opinion, what's also important is if we do not proceed this way, then the time really does not matter, because you have so much time to present your argument that you know, the whole time taking becomes redundant, because suddenly instead of having 15 minutes, you have 30 minutes.
Yeah.
Yeah.
Okay. I understand. Thank you, Mr. President.
Then,
so
whenever you're ready. Oh, yes,
Mr.
please.
President, my understanding is each of the council have her or his own time. I mean, originally 15 minutes are now 13 minutes to present. And the Q&A session is supposed to be at the end of the argumentations. So if an arbitrator raise questions and have a discussion back and forth, the council should have some compensation for the time to complete her or his opening speech. That is my understanding. So it is up to you and Mr. Tony Nguyen, but that is my understanding. Thank you.
Thank you very much. I think we did give some extension when requested, but I don't know. Maybe to be clear, would it make sense for the organizing committee to once again confirm this?
May I, Mr. President?
Please, by all means.
Just to clarify, I had like 3 matches before, and I applied exactly the same approach. I keep asking in the middle, and I'm mindful of time. If I ask too much, I'm going to give the council some extension of time reasonably. And I agree with Mr. President that if giving the full 15 minutes for Q&A, it will be too much. It will take like 3 hours for a match. Yeah.
Right. Okay. Then maybe it would be the easiest way to simply proceed on this understanding. And council, keep in mind you will get some extension, but as is common practice for the Wismut, you know, it's not chess clock arbitration, so no one stops the time when you get asked a question, and you get exactly the same number of seconds. So when we ask a lot of questions, you will get some extension, but be mindful that it's your duty to manage your time.
Yes, thank you, Mr. Arbitrator. So shall I proceed with my presentation?
Please do so.
Yes, members of tribunal and team colleagues, good afternoon. My name is Dao Chi, and I will be addressing the merits of this dispute on behalf of the respondents. Our position here is that the claimant is attempting to impose obligations on the respondent that it had never agreed to in the first place. To contradict the submissions made by the opposing counsel, I'll be making 2 arguments. First, that the parties did not conclude a contract in 2020, and second, that the claimant's GCS were not validly incorporated. Before I proceed with my first argument, I will prove that the claimant's position regarding previously established practices between the claimant and Southern Commodities is unjustifiable by putting forward 3 reasons. The first and foremost, it must be noted that even though the respondent was acquired by Southern Commodities, it is a separate legal entity. Additionally, in the present case, this is the first instance of any legal relationship between the claimant and the respondents. Also, Ms. Bubati's personal behavior in the capacity of an authorized representative of Southern Commodities cannot create a practice by allegedly similar behavior in the capacity of judge as biofuel authorized representative.
Sorry to interrupt you. If I may, Mr. President, I'm still struggling after a few matches now that you are talking about the prior practice. So my question is, you are talking about behavior. Is it behavior being determined by people and not by entities? What is your submission on that?
I understand your concern, Mr. Arbitrator. My submission is that even though the will of a company is expressed through its agents, nevertheless, the personnel transformation of Ms. Bubati does not affect does not impute the practice in which she was acting for Southern Commodities to the claimant, to the respondent in this present case.
Counselor, you would have to substantiate why you take that position, because
yes,
you just denied it without substantiating any further.
Yes, actually, I am about to prove that. Yes, thank you. So may I proceed with my arguments that in this case, in other words,
Counsel,
yes.
What I was saying is, could you please answer the question that was posed to you by my colleague? Like, why in this case does the behavior, why should it not be attributable to the company?
Yes, because Georgia Biofuel remains a separate legal entity from Southern Commodities, and according to Article 19.1 of CISG, where it's stipulated that parties are only bound by the practices that established between themselves. In this case, respondent was not a party in the previous practice, and then it should be held liable for the practice in which it is not a party. Does my answer satisfy your question?
That's to be determined later, but please proceed.
Yes, my second submission is that the claimant could not have reasonable belief that a contract will be concluded based on the previous dealings between Mr. Chandra and Ms. Bubati for the following reasons. Firstly, of the total 40 contracts, there are only an insignificant proportion of about 12% of cases where the contract was performed with Ms. Bubati's signature, and this is not sufficient to form a reasonable belief. And secondly, according to
Counsel,
yes.
do we have any indication that would give rise to doubts as regards her power to represent?
Ms. Bubati, I confirm that Ms. Bubati had the authorities to represent Southern Commodities in the previous practice, meaning that the previous practice between her and Mr. Chandra is imputed on Southern Commodities. Yes, shall I proceed, please? Secondly, according to Schrenzer in his commentary to CISG, interval is also a significant.
Counsel, who is that?
Mr. Schrenzer in his commentary to CISG.
Mr. Schrenzer.
Yes, I don't know if I pronounced his name.
Who is that?
He is a scholar who wrote the commentary to CISG.
Okay. I have never met him. I thought it was a lady, but thank you. Let's proceed.
Yes. Interval is also a significant factor when considering the existence of a practice. Here we must be, it must be noted that between 2018 to 2020, no transaction was carried out between Mr. Chandra and Ms. Bubati. And thirdly, the 2020 contract is by no means the same as previous contracts. In this case, there is no fact to confirm that the previous contracts were the long-term ones, like the 2020 contract. Additionally, the negotiation, conclusion, and performance of long-term contracts are totally different. In long-term contracts, prolonged discussions are foreseeable, and therefore, under Article 18.1 of CISG, if Ms. Bubati didn't object to or return the signed copy, it should have been understood that parties were in the negotiation stage instead of the respondent's acceptance. Turning to my third point regarding the practice, even if a practice did exist, Ms. Bubati, through both statement and conduct, had communicated that she did not intend to continue any practices. And this is evidence from the conversation between her and Ms. Chandra in the summit. Now, turning to my first main argument, the respondent argues that in any event, no contract was concluded in the year 2020 by making 3 submissions. First, that the email Ms. Bubati sent on the 1st of April did not constitute an offer. Second, even if this email was an offer, the email Mr. Rain sent on the 9th of April did not constitute an acceptance, but merely a counteroffer. And third, this counteroffer was never accepted by our clients. Turning to my first submission, Ms. Bubati's email was not an offer because 2 out of 3 requirements for a valid offer under the Article 14.1 of CISG were not fulfilled. The email was indefinite and did not indicate the intention of Ms. Bubati to be bound. And this is well proved by the fact that parties had not agreed upon a matter of particular importance, being the arbitration issues in these disputes.
Is the arbitration agreement really something of fundamental importance to commercial parties?
Yes, indeed, Mr. Arbitrator. The arbitration issues is means the dispute resolution mechanism. And for this, Article 19.1 and 19.3 of CISG pointed out that this is regarded as material terms, and also what is of utmost importance must be interpreted based on the party's intention. And in this case, it is our submission that both parties deem the dispute resolution mechanism to be of particular importance.
Everything you say makes sense, but I'm now waiting for the explanation. Why was
yes.
it of particular importance?
Yes, thank you for asking that. May I now refer the arbitral tribunal first to page 10 of the record, which is Mr. Chandra's testimony. Here in the paragraph, in the middle of paragraph 11, we can see that both parties already showed their different views on dispute resolution mechanism. And Ms. Bubati once again referred to and specified these concerns in her emails on the 1st of April. She specifically asked for a non-related industry arbitration center, and also she raised concerns pertaining to the transparency. And in Mr. Chandra's emails to her, he said that for them, agreeing on anything but arbitration would be very difficult. And this indicates that both parties deem the dispute resolution mechanism and only intended to be bound until there is an agreement thereupon.
Counsel, until there is an agreement specifically on the arbitration clause, or until there is an agreement that it goes to arbitration as such?
Thank you, Mr. President. Our submission here is that until there is an agreement on all the arbitration issues containing the dealing with the transparency rules and also the the institution, the non-related industry institution that Ms. Bubati mentioned. Yes, so I am aware that my time has exhausted. So can I ask for additionally 4 minutes to conclude, to proceed and conclude? Yeah.
Council, you still have about 45 seconds. But, you know, I think we did not ask you more questions than we asked others. So I think it would be fair, and unless my colleagues disagree, but I think it would be unfair if we gave you 4 minutes. I think something like 2 minutes, as we gave before, would be rather generous, but I stand corrected by my colleagues.
Yeah, I agree that 2 minutes is fair in my sense. Thank you.
Yes, I also agree with your decision, Mr. President.
Yes.
Thank you very much. Then, Council, you have 2 minutes.
Yes, so because no offer was triggered, then there was no contracts thereafter. Proceeding with my second argument that GCS was not validly incorporated because Ms. Bubati had no prior knowledge of such terms. You can see that in page 12 of the record, she specifically requested for a non-industry related arbitration center, which is already provided by the GCS, the post version of GCS. This means that she does not have actual knowledge of the terms. Additionally, the only information she had was via a phone call, and via that phone call, Ms. Chandra did just notified her of a change without the details of the change. So she cannot be deemed to have actual knowledge of the terms when she does not know it to a full and complete extent. And therefore, the claimant had the obligation to make the terms available. However, it didn't. So the GCS was invalidly incorporated into the sales contracts 2020. That marks the end of my arguments. Thank you.
Thank you very much, Council. Are there any follow-up questions from my colleagues?
No, Mr. President, not for now.
Okay.
Not from me, thank you.
Thank you very much. Then we will proceed with the rebuttal, and we go back to the claimant. You have reserved 2 minutes, so please start whenever you're ready.
Yes, thank you, Mr. Arbitrator. We have some rebuttal from the opposing counsel pleading. According to the Climate Exhibit 3, the page 12 at the last paragraph, that Ms. Bubati only suggested the non-industry related arbitration institution. And I believe our position is that there is no arbitration center named non-industry arbitration institution. And therefore, according to the suggestion of Ms. Bubati, claimant did give the arbitration, the non-industry arbitration institution, which is AIAC. And also, according to Ms. Bubati email, that the first paragraph that she says she would, it would good to see Mr. Chandra as the submit, and therefore it can be seen that Ms. Bubati had the intent to continue the own practices with the claimant. And moreover, in the case Northern Natural Gas of the United States Court in 1979, that the company is liable for any person, for its employee engaging in the company's activity, the duty, and the company is liable for the relevant knowledge that is acquired by that person. And what can be inferred from that case is that the knowledge that of Ms. Bubati is the reason why certain community would want to hire and divide her into to be the head of purchasing of Chaja, and her knowledge should be inputted into the parent company and also the subsidiary company. And that marks the end of my rebuttal. Thank you.
Thank you very much, Council. If there are any questions from my colleagues, then please give me a sign of hand, but I don't see anything. So let's proceed to the respondent, please. You also have 2 minutes for your rebuttal.
Yes, I want to briefly make some points to my opposing counsel's rebuttal. The first point regarding the frequency factor of a practice, the opposing counsel seems to misinterpret the terms frequency. Frequency here we must base on two elements. The first being the exact number of repeated events, and the second being that exact number in the is in the context of the total number of the duration of time or the total number of contracts in this case. So here we must take in the fact that only 5 out of 40 contracts were performed without Ms. Bubati's signature. And secondly, my second rebuttal is that the claimant tried to incorporate GCS via a practice, but as I proved previously, no practice ever existed between the parties, emphasized I did. And also they claim that they made an offer to apply the GCS. However, they omit the very most important factor, that is the acceptance on that for the offer, which does not existed from our clients. That marks the end of my rebuttal. Thank you.
Thank you very much, Counsel. Are there any questions from my colleagues now?
Yes, Mr. President. I would like to have one question for claimant counsel and another question for respondent counsel.
Please, by all means.
Thank you. For the claimant counsel, first, I understand that in your submissions, you submitted that a sale contract was formed on the 9th of April. And with that submission, I assume that it is because you consider the letter of Mr. Bugatti on the 1st of April is an offer. It must containing all the substantial terms and conditions to become an offer, right? But it is an uncontested fact that Mr. Bugatti email on the 1st of April just confirm whatever commercially agree between them on the palm oil summit. So why not a contract was formulated on the 1st of April?
Yes, thank you, Mr. Arbitrator, for your question. According to Article 14 CISG, the minimum contents only about the price, quantity, and the types of goods. There is no mention of the arbitration disputes, as my opposing counsel mentioned. And from the word in the paragraph 3 of Ms. Bubati email, place the following order. I do understand that this is some kind of confirmation upon the negotiation at the summit. However, the word order, place the following order is a word according to CISG Digest, the cloud case 330. It shows that the word order is a strong word to show the intent to be bound by the information suggested to the recipient. And that's why we conclude that Ms. Bubati email was an offer, and we did accept by the email dated 9.
Sorry, I still get a little bit confused. Assuming that we accept your position that arbitration clause is not necessary to form a contract, right? Assuming that, and only, let's say, the key commercial terms are required. But the key commercial terms already been discussed and agreed during the palm oil summit. And then Ms. Bugatti said that she needs some kind of approval and she will get back. And that is the time on April the 1st when she write back an email and saying, okay, now I make an offer. Why not a contract will formulate on the 1st of April if you consider that all the necessary terms already been discussed and agreed between the two parties?
Yes, Mr. Arbitrator. At the summit, there is only discussion about the commercial term, and the commercial term is illustrated in paragraph 3 of the C2. And the offer is, as you understand, my idea that this does not require the arbitration clause. And however, in this letter, Ms. Bubati asked about the UCITRO transparency rule, and also she suggests the arbitration institution, and because this offer, it also requires the contractual document as her suggestion as paragraph 4. She understands that the documents for the sale of palm oil will be the shortened version, and this sentence, we understand it as the intent to want the claimant to send the contractual documents, and as soon as we send the contractual document attached to the email dated 9 April, that contract is assigned for contract formation.
Okay, okay, thank you, Council. And now I would like to turn to the respondent Council with questions, maybe two elements in one questions. So we discussed a lot about the previous practice and whether that practice will be inputted to the corporate knowledge. But here we are talking something, I think, in very extreme situation where there's like 40 previous contract, right? If you and I will deal with each other, let's say for 4 transactions, we know each other quite a lot, quite very clear. But here we are talking about, let's say, 40 transactions, and to me it is a lot. And in instance, we are mentioned the fact that general condition of sale has not been provided, but at a sophisticated business party, no one from your party have asked for a copy of that document. So is that a reasonable assumption that the corporate, not only the individual, but also the corporate are well aware, or at least should have known about the content, so that you didn't make any inquiry for the documentations? Thank you.
Yes, Mr. Arbitrator, I understand your concerns. First of all, I want to make clear that the obligation stands on the claimant side, meaning that the claimant has the obligation to make the terms available, and this is also confirmed by the CISG Advisory Council by the rule number 2.6 that the offeree, meaning the respondent, had no obligations to inquire for the contents of the terms. That's the first point. And to the second point you asked, I want to mention that it is undisputed that Ms. Bubati and Ms. Chandra had concluded 40 contracts. However, things have changed, like people change every day. The contract, the context in which the formation of the previous contracts is by no means the same as the contract 2020, giving all the elements like the rising scandal of the claimant, or the fact that the respondent is now facing many difficulties in its industry. So what I am trying to say here is that the context has changed, and therefore the claimant cannot expect that the same formation of contracts will be the same as now. And also, my third point is that when Ms. Bubati concluded the 40 contracts with Mr. Chandra, she was acting as the authorized representative of the different company, and now she's an employee of the respondent, and the respondent should not be held liable for its mother company. She cannot place her previous knowledge to act for a different company. That is my answer.
Thank you, Council. And thank you, Mr. President. I have no further questions. Thank you.
Thank you very much. I have one immediate follow-up question, Council, to what you just said now. I understand where you're coming from legally when you say whatever happened at the previous company cannot be, brought in here. But do you think that in reality, commercial parties differentiate that much? That they say, oh, now you're at a subsidiary, before it was the parent company, so now everything that happened before, we have to forget about it?
Yes, I understand your concern, but business is business, in my opinion. We do have that long-lasting, let me just say, that friendship relationship, but when we do business, we must rely on the law, the legal basis, and also the commercial terms that are the determined factors. So although our clients really appreciate that long-lasting relationship with the claimants, but the legal basis here, all that we got in this case supported that there is no practice between the parties, and the claimant therefore cannot impose obligations on the respondent.
Okay.
Thank you.
Thank you very much, Council. Are there any further questions?
May I have some questions?
Please.
Mr. President. Unfortunately, I have quite a lot of questions. I will try to shorten them and to avoid duplicate if I heard it somewhere. One following up question is from the responses by the claimant, by the second claimant's counsel, Ms. Ming, where you said that after the parties have agreed, maybe in the summit, for example, or whatever they agreed in the reflected in the offer made, there must be some contractual documents to reflect that. I just want to clarify whether you are submitting that there must be some written documents to confirm the parties' agreement, even if they previously had conducted the offer and acceptance properly. So that's my first question. Maybe you want to ask to respond to my question now. So I move on to the next question.
Yes, thank you for your question. According to paragraph 4, that Ms. Puberty, of page 12, Ms. Puberty did require the claimant to send the necessary contractual document for her signature, and also for the administrative task to keep those documents as a record of as an evidence of the transaction. And I understand that in this case, this email in another circumstances, if it was a letter of confirmation according to what was discussed as the summit, then such letter of confirmation can be considered as a contract was concluded between the parties. But in this case, this email is not a letter of confirmation, and it states that Ms. Puberty requires the contractual document for the further step, and that's why the email dated 9 with the contract is totally a contract.
May I get just a yes or no answer from you? Do you think that not related doesn't necessarily related to this case? If, let's say if, the parties have offered and accepted properly, when is the time the contract is formed? Is it when the contractual document is signed, or is it when the acceptance is made? Do you understand my question?
Um, According to Article 23 of CISG, a contract is concluded at the moment when the acceptance of the offer becomes effective. And however, in this case, our position is that
Counsel, you don't need to elaborate. I already get the answer. Thank you. I move on to my second question. I'm quite surprised that you do not address Mr. President's question very straight on the pricing of the offer that is allegedly made in the email dated the 1st of April. In fact, the third paragraph said that the commercial agreement was 20,000 tons of RSPO certified palm oil per annum for 21 to 25 CIF delivery up to 6 installments. And the first year was USD 900. Thereafter, the market price. My question is, because we know only the first year and the second year and the third year, we don't know yet. And you did not give any answer as to the determination of that market price, because the market price could be anything between like a Vietnamese association on palm oil, or an international palm oil association, or maybe the party's reference to any other index. So my question is whether or not we could say that the price has not been fixed, and therefore it's not an offer, unless you may want to talk, you may want to submit something in relation to Article 55 of the CSG. I don't normally raise this type of reference to the authority, but I'm quite curious why the councils of each side did not ever mention this article. I'm just curious.
Yes, Mr. Arbitrator. I was gonna explaining the market price according to Article 55, as you just mentioned before, that it is not necessary to fix the price at the offer. And if there is no fixed price at the offer, Article 55 will be related. And in this case, we did not mention the market price because we believe that at the summit, Mr. Chandra and Ms. Puvati did negotiated on the favorable price, and she also understands that RSPO certified palm oil is a kind of expensive product, and what Mr. Chandra offer is kind of a good bargain to Ms. Puvati, and therefore she Ms. Puvati did not ask for further reduction or maybe increase of the price, and it's like she was happy, and she find that price is satisfying to her, and that's why the both party we do not have any dispute on the price of the contract.
So is that you submitting that the parties have actually agreed on the price, and it doesn't need to appear on the offer letter? I mean, to me, it's not obviously clear. Maybe the first year could be sufficiently definite, but I don't know what the price for the second year or third year.
Yes, the price for the third or the second or maybe the fifth year will depends on the market price, and frankly speaking, we cannot decide at that year what is the market price, because it depends on the market, the demanding and the buying amounts of the buyers. Yeah. And yeah.
All right.
And
I will not make you more trouble because this has already been asked by our president. Let me ask the respondent.
Yes, Mr. Administrator.
The same question is quoted to you. Let's say if I assume that Article 55 is considered by the tribunal in determining that this has been confirmed. What is your view, or do you have any submission on that particular price? And the same issue has been raised before. You said that in your submission, you said that it's a long-term contract in 2020. So it must be different from the previous contracts.
Yes.
Okay, so can you elaborate why do you think it's different? And can you make your submission, if any, on the possibility of the Article 55 in determination of price?
Yes, I understand your concerns. But first of all, regarding the Article 55, it is our submission here in this case that the price was not expressly and fully determined by the parties, and this is one of the factors that makes Ms. Bubati's emails dated the 1st of April insufficiently definite, and therefore it is not an offer. Actually, this is one of my submission, but however, I ran out of time and I didn't have enough time to raise it. And the second point, the second questions of yours regarding the long-term, the difference between the long-term and the short-term contracts, right? It is my submission here is that in this case, there is no confirmation that the previous contracts are the long-term contract as in 2020, and this leads to the difference between the negotiation as well as the confirmation of the previous contracts compared to the present contract in 2020, because we all know that different contracts, we all know that the nature of the long-term and the short-term contracts are they're in principle very different, because for the short-term contract, the parties when parties enter a short-term contract, they're looking for like the short-term benefits, whereas for long-term contract, it's like a way of investment, a long-run investment, and therefore the formation of long-term contract is totally different from the formation of short-term contract. For long-term contract, prolonged discussions is projected. Parties have to, when they have to invest more money in a contract, because long-term contract usually has like larger monetary values compared to short-term contracts, so they have to put in there more consideration, more negotiations, and therefore in this case, applying to this case, when Ms. Bubati did not raise objection or did not return a signed copy, the claimant cannot say that she impliedly accepted to their offer, because previously the objection was usually raised within 1 week. But maybe this is just for the short-term contracts. For the long-term, as I said previously, it must be different. Things must be treated differently. Yeah. So
thank you, Council. May I make it like a more simplistic approach for you to consider to submit your position? Let's say if this tribunal accepts the position that the first year price has been fixed. So let's put it as a short-term contract for the first year, and we let's forget about the next year price, which has not been precisely determined because we cannot like find any index to the market price. Would you accept that position, as a middle position, that instead of a long-term contract, this tribunal will agree that a contract has been established as a short-term one-year contract and the commercial term has been fixed by the parties? What is your point of view?
Yes, I understand your concern, but unfortunately, our client would not accept this approach because when first of all, I will talk about the intention of the claimants. When Mr. Chandra approached Ms. Bubati, he wanted to sell a very large amount of goods, of his oil. And from Ms. Bubati's perspective, she also wants to invest in the long run, and that is why she expressed her deep interest for Mr. Chandra's invitation, because with the long-term contracts, she would be offered the very competitive price, for example. And what I
sorry
want to
interrupt you.
here
It's market price, so it's not really something like discounted. In the long run, if you say it's a market price, to me it means nothing. So let's focus on whether or not first year is accepted or it's not accepted. Are you submitting that it's like a full all or nothing offer?
Yes, actually it is our stand that we must respect the party's intention. The party's intention here is that to enter a long-term contract, not a short term. So therefore, until now, up to this arbitration proceeding, I understand that it is my client's view that they would only accept to they want to stick with their initial intention.
All right. Thank you. Thank you, Council. I have no further question. I will give the floor back to the President.
Thank you very much. I have one really quick, again, practical question, and I hope I don't come across as biased, as I didn't ask the claimant any additional questions, but Council, you always trigger those practical questions in me based on your answers. So you said here that long-term contracts require, if I understood it correctly, they require more investment, and the profits are usually reaped at the end. Did I understand it correctly?
Mr. Arbitrator, what I was trying to say is that for long-term contract, parties have different purpose. They have different purpose for long-term contract and for short-term contracts. Maybe it is the purpose regarding the monetary value, or maybe it just simply the purpose for establishing a long-term relationship, whatever it is. But what I was trying to say here is that the purpose, the intention of the parties when they enter whether a long-term contract or a short-term contract is different.
Okay. My understanding is that the purpose of every company is to be profitable.
Yes.
And this is where I'm aiming at. We don't know what the market price is, but let's assume that there are not considerable changes. Let's assume it remains in the 900 range.
Yes.
Would the parties in this case make fewer profits in the different years? I'm again coming back to what you said, that you pointed out that for short-term contracts, the goal is to have profits on the short run, but for long-term profits, you said it's to establish a long and lasting business relationship. It seemed to me that your emphasis was much less on being profitable.
I understand your concern, but actually, this is my client's initial intention to enter the long-term contract with the respondent. That is my first stance. And secondly, I understand that when they want to establish to enter a long-term contract with the claimant, they are not only hope for the profits. Of course, the profits is one of the most important factors for every business. But
okay. Now, Council, having heard you say that, that answers my question. So thank you. And it doesn't mean that you were wrong. So just because I cut you off doesn't mean that it was bad. No, not at all. So please don't take it the wrong way. I also have to manage this tribunal's time to some extent, and I'm not sure I was very good at it, but I think we can close the hearing here at this point. As the presiding arbitrator, I have the honor of thanking everyone involved. This goes first and foremost, of course, to the parties. It was a great pleasure. But of course, and you know, not any less important, it also goes to my two colleagues and the great questions they were posing to the parties. So thank you very much to everyone. I have just received a message from the organizers that the arbitrators will go to a different room. And could I quickly confirm with my two colleagues that you have received the link in the chat as well?
Yes, I have.
I do.
I can move to there. Thank you.
So we will move there. And after our deliberations, we will come back and let's see what happens then. But once again, thank you very much to everyone involved. It was a great pleasure. Thank you.
Thank you. Thank you, Mr. President. Thank you, parties.
Thank you.
Ladies and gentlemen, that concludes the final match of the Vietnam CIG Premier 2022. Congratulations both teams on their outstanding performances. Ladies and gentlemen, that was the last moment of the final match at Vietnam CIG Prix 2022. Both teams have delivered the excellent presentations. We are taking a short break to give time to the audible arbitrators to calculate the marks. The result will be announced soon. Ladies and gentlemen, we have prepared a mini game for our viewers while waiting for the result from the arbitrators. There are 5 questions in total related to the competition, and each had only one correct answer. The fastest who give back the accurate answer shall receive a present from the organizing committee. For each question, you have 30 seconds to answer, and you can interact by typing your answer in the comment section following the pattern. Your name underline answer. The organizing committee will record your answer in order to select the winner of a question via our live stream on fan page Vietnam CIG Premier. Now, we shall begin the mini game. So we should move to question number 1. What is the alternative name for CISG? A, the Vienna Convention. B, the New York Convention. C, the Paris Convention. And D, the Berlin Convention. The viewer have 30 seconds to answer the question. Dear the audiences, so the time for the question number 1 is over. I should announce the answer for question number 1 right now. The alternative name for CISG is the Vienna Convention. So A is the right option. Congratulations to the viewers who have chosen the option A. So now we move on to the second question of the mini game. Question number 2. How many countries have signed CISG? A, 90, B, 92, C, 94, and D, 96. You also have 30 seconds to answer the question. So the audience, that is the time is over for question number 2. So this number of countries that has signed CISG to this day is C, 94. So congratulations to viewers that choose the option C. Now for the next question. Question number 3 is, when did Vietnam join CISG? A, 2014, B, 2015, C, 2016, and D, 2017. You also have 30 seconds for the question. Dear viewers, so the time for the question number 3 is also over. I should announce the answer of question number 3. Vietnam has joined CISG in the year of 2015. So B is the correct answer. Question number 4 is next. The request of question number 4 is fill in the missing information. Vietnam is the member of CISG. A, 81st, B, 82nd, C, 83rd, and D, 84th. You also have 30 seconds, so please hurry the viewers. Dear viewers, the time for question number 4 is finally over. And the answer for question number 4 is, Vietnam is the 84th member of CISG. So D is the correct answer here. So our mini game has come to the last question. Question number 5. And when was the first time Vietnam CISG premier took place? A, 2019, B, 2020, C, 2021, and D, 2018. You also have 30 seconds for the last question. So the last question, then question number 5. The question of us is, when was the first time Vietnam CISG premier took place? And the correct answer is A, 2019. So that is the final question for the mini game today. Thank you all for all your responses. We will announce the winner for each question shortly after. The winner can update the post announcing the results of the minigame and contact us via fan page Vietnam CIG Premier 2022 to claim your prize. Ladies and gentlemen, to get to this final match, Vietnam CIG Premier 2022 had witnessed 4 intense rounds, starting from registration, preliminary round, elimination round, quarterfinal, and semi-final round. But for the help from the sponsor, Vietnam CIG Premier 2022 wouldn't have come off like this, and we really appreciate your company.
Please see your vote.
Besides the contestant today, we would like to acknowledge the significant roles of arbitrators who are present in today's competition and in charge of choosing the champion. First, I would like to ask Mr. Harris Simple, what do you think about the teams that participated in this year's competition?
Well, thank you very much. As I pointed out at the end of the match, it was a great pleasure. And you know, when you go into a match as an arbitrator, you never know what to expect because you don't know what the quality of the team is going to be. And when the teams are, I don't want to say not so good, let me put it this way, when the teams have a lot of room for improvement, the experience is always less enjoyable because it's, you know, as a lawyer, when teams don't get very important arguments, it's a bit painful. But as I pointed out, this match was a lot of fun. It was a great pleasure. This does not mean that the two teams were perfect. I think both teams still can improve a lot, and I hope you see from our questions where there are possible weaknesses in your points. But you know, focus on this and try to improve even further. But as I said, and that's my conclusion, it was a lot of fun and I very much enjoyed this. So thank you very much to 1999, 2000, 2001, and the Masters of Mystic Arts.
Thank you.
Thank you, Mr. Harris Subol. And now I want to ask Mr. Nguyen Trung Nam, what are your impressions that the two teams have left of you?
Thank you, MC. Firstly I had to admit that I'm very happy to participate in today's hearing session as arbitrator with old friends Harold and Chung. We did not expect to meet each other here, and and regarding the teams, I had the pleasure to attend several previous matches and with one of the teams, and that's why I try to stay passive a little bit when I ask the questions to one of the teams. I don't want to be biased because of my previous experience with that team. I have to say that both teams today are performing very well. And your English is perfect, a lot better than our generation when we were at your age. We find it very difficult even to say salut to the tribunal members. And you have got a lot of preparation. What else can I say? Similar to Howard, I think you will have quite a room to improve. I have arbitrated East pre-moot with Indian, with European teams, and with a lot of Asian teams as well. And I also did the ICC one. And for the previous year, I attended as an arbitrator of the moot, the Viz moot itself. So I realized that there's still a gap between the Vietnamese competitors and the very top oralists, in that you haven't approached to the very heart of the some of the detailed issues. So if you go to a level of details that surprise the tribunal, then you will get more marks. And secondly, I echo Harold in saying that when you are asked by the tribunal very typical basic questions, try to answer, try to improve by answering the precise, giving the precise answer, and try to learn and broaden your knowledge to, for example, practical issues, and also your knowledge on general arbitration, so that you can address the questions, various type of questions from the tribunal. And Harold today is an example of very tough arbitrator. So if you see similar arbitrators from other jurisdictions from all other parts of the world, you will find such difficult questions, and you have to be able to deal with all of them. Try to be precise, short, and straight to the point, and do not explain too much out of the context that you need to. All our time is very precious. Arbitrators' time are precious, and you have a duty to not to waste the time of yourself and of the tribunal. So that's all I can say. And again, congratulations both teams, and whoever win today, you will deserve it. Thank you.
That this are not only giving the teams compliments, but Mr. Nam also give them some advice and feedback so that they can improve their abilities and their chance of winning if they are intend to move on to the Viz moot or further. So that is the sharing of Mr. Nguyễn Trung Nam. What about Mr. Lê Bảo Thành Trung? What do you think about the finalist performance today?
Thank you, Ms. MC. First of all, I would like to concur the comments Harold and Tony. I think they are great. They are very helpful. So if one of you can take advantage of that, that would be helpful for you for sure. Then I would like to say thank you and congratulations. Generally speaking, both parties did a great job today. I have a pleasure of enjoying the match today. Really, at my generations, I cannot see how could we achieve such kind of knowledge, confidence, not only English skill as Tony mentioned, but the degree of confidence and knowledge, skill, everything is much better than our generation. So I have a confidence that you guys will do much better than what we could do in the past. I also agree with Tony that there's room for you guys to improve and immediate purpose for the moot court in the near future. If some of you or all of you are about to attending that moot activities, so I hope that our comments today, questions sometimes is challenging or difficult. Will give you some helpful tips and ideas of how you can improve the area that you can make it better in the moves where you have a stronger opponents or team from various other places. So again, thank you and congratulations. Really, you guys make us a very tough job of deciding who is the winner today. It is a hard discussion in the deliberation room. So whoever win today, whoever couldn't win today, because we only have one prize to keep today. So you did an excellent job, and you make us very difficult time to decide. So you should be proud of that. Thank you and congratulations.
Well, thank you, Mr. Chung, for the sharing. I heard that all the arbitrators have said that there are room for the contestant to improve further. But anyway, they have done a great job for today's performance and hope that they can improve their views better in the future. So moving back to the two teams today, Team 1900 and Team MMA, I'd like to have a short conversation with Team MMA first. So yes. Nervous and comfortable, which words is best to describe your current feeling and why? Can you share it with us?
At this very moment, I am saying I am comfortable more than nervous, because first of all, I know that we have finished a very long journey, and reaching to this point today is something that is for me is more treasurable than the actual prize. So I think that I can let my hair down now and just enjoy the moments. So I'm feeling more comfortable than nervous.
The Team 1900 also want to share something, but I think that both the teams are more looking forward to know the result more than just talking about the performance. So I think we should move on to talk about the prize structure. So ladies and gentlemen, the result already in my hand, but before that, I would like to reiterate the prize structure of the Vietnam CIG Premier 2022. This year, there are two prizes for co-third prize, and each worth 5 million Vietnam dong. For runner-up, we have one prize worth 10 million VND, and this year's championship will be awarded 15 million VND with a token of appreciation. Besides the major prizes, we have 4 other awards respectively. The favorite team worth 1 million VND, the best oralist, which is worth 1 million VND, the best outline for claimant, and the best outline for respondent, each worth 2 million VND. Furthermore, each team will make it to the top 20 will receive a certificate for your certification. Now, let's reveal our favorite team based on the information we gather on the fan page of Vietnam CIG Premier. Congratulations to Team MMA. You have become the most favorite team of this year. You will be awarded 1 million VND from the organizing committees. For the best outline for claimant, congratulations to Team Hobbit. The best outline for respondent. Let's also go to Team Hobbit. Well done, Team Hobbit. And from the score given by the arbitrators, the best oral rates of this year is Mr. Dao Lingqi from the Team MMA. Congratulations for your personal awards. For now, I would like to announce the winner of this year's season, starting from the 3rd place. Please give a round of applause and congratulations to Team Parmesan and Caesars. Congratulations to both teams, and what impressive achievement. Each team will receive a certificate for your efforts, and you've made 5 million VND prize. Thank you a lot for participating in Vietnam CIG Premier 2022. Now, this is the moment that we're all waiting for. 2 teams left, meaning one named champion of Vietnam CIG Premier 2022. The winner of this year goes to Team MMA. Congratulations, Team MMA, again, to becoming the winner of this year. And also congratulate to Team 1900 for winning the runner-up prize, which is worth 10 million dong. You have put a lot of effort in this journey, and this will be a remarkable experience to all of us. We hope that this competition will be a memorable experience for all the contestants and for the viewers who have participated in our mini game during the break time. Please keep yourself updated with our latest post on the via fan page Vietnam CIG Premier to claim your prize. Thank you all for your interaction and participation. Well, now I want to get back to our winner, Team MMA. Congratulations to our champion. You have done a great job. Can you tell us what's on your mind after being the winner of Vietnam CIG Premier 2022?
I believe all my teammates are so overwhelmed, so I will speak on behalf of them. Really, I just don't know what to say. Yeah, of course we do hope for the best, but I just cannot believe that we make it so far. Thank you to all. Thank you for all the support, for all the love, and yeah, and we couldn't have make it without all of you. Thank you, really.
Well, thank you very much. I do believe that this will be an unforgettable memory for your team. Now I want to get back to Team 1900 because I have also want to congratulate you on the performance in this final round. Well, I want to ask what you feel after the match and what you think about your rival.
Yes, firstly, thank you so much the organizing committee and also the panels for this wonderful match today. Talking about our feelings right now, we still feel like over the moon for being the runner-up of the match today, because to be honest, our team doesn't have much experience in mooting competitions, and specifically for myself, this is the first time I attend in a moot court competition. So who would have thought that a very young and lack of experienced team like us to go to the final round. And for us, this is definitely a wonderful experience and a remarkable experience that we will have in our career path in the future. And we're also totally impressed by the opposing team's performance. It was truly worth it, and your championship is really got our respect, and thank you guys so much.
1900, I understand that you have done such a great performance for a first timer, and even though you lack of the experience, you two make it to the final round today, and we all recognize your performance and your talent. So thank you very much. That is the end for the exchange with the champion and the runner-ups. Ladies and gentlemen, throughout many intense rounds, we have found the most outstanding team among 96 teams to be the champion of Vietnam CIG Premier 2022. We, the organizing committee, would like to send a special thanks to the arbitrators, Mr. Hara Sipol, Mr. Nguyễn Trung Nam, and Mr. Lê Bá Thành Trung. Also, we want to thank our sponsor, include Zoom and Associate, DNR Vietnam Chambers LLC, Hợp Đặng Chamber, and Appellate Legal. We also recognize our co-organizer and supporting units, Foreign Trade University FTU, Vietnam International Arbitration Center VIAC, Vietnam Society of International Law VSIL, and Vietnam Business Law Club VBLC. We also thank you to supporting units, includes CIG Vietnam as the professional support unit, and Law Consulting Club LCC FTU as the organizational support unit. Thank you for your interest and assistance. Without further contribution, this event would not have been such a success. For everything you have done for us in the competition, everything you still do and continue to do, we, the organizing committee of Vietnam CIG Premier 2022, want to express how thankful we are and how we look forward to the future of us together. Furthermore, thank you to all the contestants and the viewers to making all the contests possible. Dear viewers, I would like to declare that Vietnam CIG Premier 2022 has finally come to a halt. Ladies and gentlemen, it was a long ride, yet an unforgettable moment for all of us. Thank you for accompanying with us to the end of the competition. Farewell, and hopefully see you in Vietnam CIG Premier 2023.
Thank you.